An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. Roe v. Wade, 1973.
Good evening. In a landmark ruling, the Supreme Court today legalized abortions. The majority in cases from Texas and Georgia said that the decision to end a pregnancy during the first 3 months belongs to the woman and her doctor, not the government. Thus, the anti-abortion laws of 46 states were rendered unconstitutional.
To this day, Roe v. Wade remains one of the Supreme Court's most controversial opinions. As a general matter, states have the police power to criminalize murder, that is, the taking of a life. Does the police power then give the state the power to criminalize an abortion? Our analysis starts with the text of the 14th Amendment. The Due Process Clause provides, "Nor shall any state deprive any person of life, liberty, or property without due process of law." If terminating a pregnancy constitutes liberty, then the state cannot deprive a mother of that liberty without the due process of law. On this theory, the 14th Amendment would protect the right to have an abortion nationwide, unless a state can show that its specific law is valid. However, the 14th Amendment does not only concern the rights of the mother. The Equal Protection Clause requires us to consider the legal status of the fetus. It provides, "No state shall deny to any person within its jurisdiction the equal protection of the laws." If the fetus is a person, does the state have a duty to equally protect born and unborn persons alike from murder? If so, on this theory, abortion must be prohibited nationwide. And Congress could then use its powers under Section 5 of the 14th Amendment to enact appropriate legislation to criminalize abortion should a state fail to do so. The crux of the equal protection theory would then turn on when a fetus becomes a person, and if abortion is considered to be murder. However, even if abortion is not considered murder, a state could still ban the procedure. Under the so-called police power, states argue that they can prohibit a wide range of immoral conduct, regardless of whether it harms another person. For example, states can criminalize animal cruelty. Under this conception of the police power, the decision of whether or not to prohibit certain types of immoral conduct is left to the states. Accordingly, conservative states could ban abortion while more liberal states can legalize it. Whether this federalism option is available, therefore, turns on the scope of the state's police power. Prior to Roe v. Wade, many states banned almost all abortions. Texas, for example, criminalized abortions unless it was needed to save the life of the mother. In 1970, Norma McCorvey challenged the constitutionality of Texas's abortion law. McCorvey told the police that she was raped in order to procure a legal abortion. However, McCorvey later admitted that she fabricated the allegation. She also attempted to obtain an illegal abortion, but the clinic had already been shut down. Instead, 2 attorneys recruited McCorvey as the lead plaintiff to challenge Texas's law. She filed the suit under the pseudonym Jane Roe.
My name is Norma McCorvey, aka Jane Roe.
The case was appealed to the Supreme Court. Roe's attorney argued that Texas's abortion law was unconstitutional under
the 5th, the 9th, and the 14th Amendments.
She added,
"There's a great body of precedent."
The leading precedent was Griswold versus Connecticut. Study guide: Is there a difference between the constitutional basis of Griswold and that of Roe? In Griswold, Justice William O. Douglas found that, quote, "Specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance." He added, "Various guarantees in the Bill of Rights, including the First, Third, Fourth, Fifth, and Ninth Amendments, create zones of privacy." Justice Douglas concluded that this right to privacy included a right of married couples to have access to contraception. However, in Roe, the court seemed equivocal about the basis of a right to abortion. Justice Harry Blackman wrote the majority opinion. He wrote, "This right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action, as we feel it is, or as the district court determined in the 9th Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy." The court added, quote, "Only personal rights that can be deemed fundamental or implicit in the concept of ordered liberty are included in this guarantee of personal privacy." Ultimately, the court rested its decision on the Due Process Clause of the 14th Amendment. In court, Texas argued that the
state had a compelling interest because of the protection of fetal life.
The court agreed in part. The state retains a definite interest in protecting women's own health and safety when abortion is performed at a late stage of pregnancy. Critically, at some point in pregnancy, the state's interests become sufficiently compelling to sustain prohibitions on abortion to protect fetal life. The court found that the mother's right to an abortion and the state's interest in regulating abortion changes throughout the 9 months of the pregnancy. In the first trimester, the state can only regulate the qualifications and licensing of doctors and facilities that provide abortions. However, during this time, the state cannot prohibit or even restrict abortions in order to protect fetal life. Prior to the compelling point of viability, quote, "The attending physician, in consultation with his patient, is free to determine, without regulation by the state, that in his medical judgment, the patient's pregnancy should be terminated." During the second trimester, the state can regulate abortion in ways reasonably related to maternal health. Only in the third trimester, subsequent to viability, to promote potentiality of human life, a state may regulate and even ban abortion, except where necessary for preservation of the life or health of the mother. Justice Blackman explained that his decision, quote, "leaves the state free to place increasing restrictions on abortion as the period of pregnancy lengthens, so long as those restrictions are tailored to the recognized state interest." The vote in Roe was 7-2. Justices White and Rehnquist dissented. Justice White wrote, quote, "I find nothing in the language or history of the Constitution to support the court's judgment." As an exercise of raw judicial power, the court perhaps has authority to do what it does today. But in my view, its judgment is an improvident and extravagant exercise of the power of judicial review that the Constitution extends to this court. Justice Rehnquist wrote that the majority opinion is closely attuned to Lochner v. New York. Quote, "As in Lochner," he wrote, "the adoption of the compelling state interest standard will inevitably require this court to examine the legislative policies and pass on the wisdom of these policies in the very process of deciding whether a particular state interest put forward may or may not be compelling." He added that, quote, "The decision here to break pregnancy into 3 distinct terms and to outline the permissible restrictions the state may impose in each one, for example, partakes more of judicial legislation than it does of a determination of the intent of the drafters of the 14th Amendment." In a concurring opinion, Justice Potter Stewart formally embraced the concept of substantive due process. He wrote, "As so understood, Griswold stands as one in a long line of cases decided under the doctrine of substantive due process, and I now accept it as such." To call the legitimacy of Roe into question, Stanford law professor Gerald Gunther paired Lochner with Roe in his widely used casebook. By the time Roe v. Wade was decided in 1973, Norma McCorvey had already carried her pregnancy to term. She gave her third child up for adoption. In the 1980s, she became an icon for abortion rights groups. However, later in life, McCorvey changed her stance on abortion. She became a born-again Christian.
This was Norma McCorvey less than 8 months later.
And served as an advocate for the pro-life movement.
This is the day that I have been waiting for.
She regretted her involvement in Roe v. Wade, which she called the biggest mistake of my life.
I'm fighting for life instead of death.
You think Roe v. Wade will be overturned?
Yes. I hope so.
In our next case, Planned Parenthood versus Casey, the Supreme Court would consider whether Roe should be overturned.